Hello, everybody. My name is Dan Muirman. I'm a SCORE mentor, and I'm with Michael Steele, who'll be your presenter today. Before he gets started on today's webinar on business contracts, I want to remind you to post your questions in the chat, and we will pick them off as we go. And there'll be plenty of time for Q&A at the end. So don't worry if he doesn't get to them right while he's talking. We will pick them up as we go. And now what I'd like to do is just briefly share my screen and tell you a little bit about SCORE. Whoops. Hit the share button. Right, it comes down. This comes up. All right. So welcome everybody to another SCORE webinar. SCORE is the largest network of free volunteer small business mentors in the nation. No matter what stage your business, SCORE has a mentor for you, and you can easily request a mentor to help you start, grow, or transition your business today. SCORE's mission is to foster vibrant small business communities through mentoring and education. We aim to give every person the support they need to thrive as small business owner. Small business drives our national economy through business formation, job creation, and wealth building. Small businesses are critical to vibrant communities in our society. There are over 10,000 volunteers in 1,500 communities. SCORE is now 60 years old, and volunteers give freely of their time, energy, and knowledge to help others, including you. We have a policy of ethics. We're not permitted to make money from SCORE clients. We do not use client or member information for commercial reasons, and all client information is confidential and protected by the U.S. government, specifically the Small Business Administration. This is our website. Go to score.org/Cleveland to sign up for a mentor to help you with your small business. The SBA is a proud supporter of SCORE. We receive financial support from SCORE so that we are able, from SBA, so we're able to deliver all mentoring services at no charge. And there are also a few generous sponsors. If you want to get more information or just go to our website, let me give you a moment, if you're not watching this on your phone, to grab this QR code, which will give you the link to www.score.org to find a mentor. And now I'm going to stop sharing and turn this over to Michael Steele. Michael, it's yours.
Yeah, I'm trying to share my screen right now. There we go. Everyone see my screen? Thanks, Dan. As he mentioned, my name is Michael Steele, and I am a subject matter expert for SCORE. I am, here's a bit about me. Everything's very slow today. I'm clicking. I am actually an intellectual property attorney. I focus on patent drafting and prosecution. So I help companies grow their IP portfolio by taking inventions that are at like the prototype stage, drafting a patent application, and then filing the application and dealing with the maze of the Patent and Trademark Office to hopefully get an issued U.S. patent. This particular area of contracts is not my specialty, but I was asked if I could fill in to help all the business owners. Because as you can imagine, in patent law, we do have to read a lot of contracts. It's not really something that I consider myself an expert in, but I can certainly help everyone navigate how to read a contract and interpret one. And as a result of my lack of expertise in contracts, I did want to emphasize that this is for educational purposes only and definitely not legal advice. In fact, you know, some of the more nuanced things, I'm sure that people more experienced in the area of contracts would disagree with me because they might see, you know, courts interpret things a certain way. You should absolutely contact your attorney and consult with your own attorney for specific legal issues, and no attorney-client relationship is established with anyone on this call. In fact, as a membership to SCORE as a subject matter expert, I agreed that I would not represent anyone through SCORE and just focus on giving some legal education. So what can you expect good from this presentation? We're going to talk about the major types of contract provisions, basically a high-level overview, and how each types of provisions are interpreted, and what provisions are important to business owners, and try to talk about where there might be room to negotiate, and then we'll have a small section on insurance. One of the things to understand with contracts is a lot of times just because you're a business doesn't mean you can negotiate a lot of contracts. Even with my law firm, a lot of our contracts are take it or leave it type of situation. So you can always ask for negotiation, but you're not always going to be granted it. So as business owners, if any of you have been running a business for probably more than a month, you'll probably have at least considered entering into a contract. And so that's why it is absolutely paramount to at least understand the basics of contract law. If nothing else, the more you understand contracts, the better consumer you're going to be of legal services. So if you're working with your attorney and you understand the general concepts in contracts, you can almost always get better outcomes than somebody that, the attorney is basically the only one that in the room that understands the material. And the second issue there is a lot of consumer protection laws, and Dan and I were actually just joking about the end user licensing agreements for software and some of the ridiculous provisions that can be in those. And some of them are actually unenforceable by statutes. But a number of times you will find that those consumer protection laws don't protect businesses. Most courts make the presumption that when two businesses enter a contract, that they're on equal footing as far as the negotiation power. That's not realistic in the vast majority of cases. If you're a small business, just a two people business or a solopreneur trying to contract with AT&T to get your phone system in, I can assure you your negotiation power isn't going to be strong. But a lot of times courts are still going to fictionally assert that that you were in a better position, because at the very least, if you're running your own business, you're going to be expected to to be a sort of a cut above the general population as far as ability to negotiate your daily affairs. And so as a result, you really will be held to a higher standard than the average person in a contract. And if there is anything that you should take away from this whole webinar, is that you need to read your contracts, especially the contracts that are more than a single day. Like if you're just buying something or whatever, you want to read through the contract. But when you're contracting for services, or if you're contracting for rental space, and those contracts are going to last a long time, you had really better be certain that you understand what you're agreeing to. So let's talk about the major types of law that relate to contracts. There's contract law, statute law, and common law. The contract law is actually, you can consider that to be private law. So that is the terms of the contracts, the terms and conditions of the contracts the two parties agree on. That aren't specified anywhere else, but they're, the basic rules that these two parties agree to do. And if they don't do them, that there will be some sort of legal remedy for a breach. And statute is the laws that when you hear about like Ohio Revised Code or federal registers, all of the usually USC it will be how they announce it. All of these laws are passed by either federal or state Congress, or in my case in North Royalton, Ohio, it's going to be the local legislature. and all of them are going to have their own sets of rules. And they're going to spell out the broad concepts for what they want the law to be. Common law, which is just as important as statutes, is how the courts interpret laws. Now, those are basically when a court creates a new law by making a first ruling on something, the next judge is expected to use the previous rule, the precedent, as guidance for the new for the next ruling. It allows people to be able to rely on the courts, not completely change, go 180 degrees every time a new situation is arising. And the great deal of that, particularly when it comes to contracts, is how they're interpreting the statute. And so I'm going to give you an example that I'm very familiar with in patent law. The statute of patent law says that to get an invention, it has to be novel and non-obvious, meaning that it has to be new and it has to be different enough from what's out there currently that it wouldn't be obvious to one of ordinary skill in the art. So in that scenario, the courts came up with a bunch of different tests for determining if something is obvious and non-obvious. I don't want to go too far down this rabbit hole, but as the basic framework for that, what they do is they look at the current state of the art, the difference between your invention and the state of the art, and then the level of ordinary skill that's available in the art, and then make that determination. So they set up like a 3-factor test to determine if there's an obvious invention, or if this is considered something that's worthy of a patent. And there are tons and tons of examples like that, because the statute for the current version of obviousness goes back all the way to the 1950s. And since then, there have been, thousands of court cases that have nuanced and given exceptions and whatever to the rules on how that's interpreted. So the statute and common law go hand in hand. And a good lawyer will be able to tell you the current trends of the court, even if the statute hasn't changed in quite a while. Types of contract provisions. So there's a big list, and we'll try to go through each one, so I don't think I need to read them right here. You have your introduction paragraph, and basically this is sort of setting up who the parties are and what type of agreement that they're entering. A lot of contracts, particularly leases, are going to be templates where they might even have the preamble refer to the to an external document, to an appendix that is attached to the contract, and basically that way then, like appendix A, subsection whatever, names the parties, and that way they can have sometimes non-legal people draft just filling in the form, and it converts that into a contract. I'm just seeing that as a common approach especially when you're dealing with large companies that lease a lot of property. But this should be relatively easy to read, and it should be very clear that this was crafted for this particular agreement in the ideal scenario. I know you just mentioned the template, but normally if you're having a contract, this would be not the part that you would repeat every time. If you're crafting, if you're pulling contracts and putting, piecing them together from previous contracts, you would typically rewrite this one for each new deal that you were working. The definition section. This is extremely important for a lot of contracts, particularly service contracts, where I see people have tons and tons of trouble, because you're going to have the definitions that identify the parties, but then you'll also have sections like what they're talking about in the slide, where they have the business day. There's no problem here with the definition of business day. But what I see a lot of issues on service contracts, for instance, homeowner association contracts for ice removal, they'll say that it has to be done in a reasonable time. and it doesn't really define what that means. And that can be very, very frustrating, because if you try to, if you try to fire the service provider and they say that my contract says it's a reasonable time, they said, well, you don't have a reason, you don't have, a default, you don't have a breach or anything. I haven't done it yet, but it's still within this reasonable time. And, and the courts will say, well, you didn't require a more narrow definition. This is something that you, as business owners, especially for service contracts, need to make sure that it's very clear of, what would be considered an acceptable, the acceptable definition for each term. Because, in my mind, going back to the snow removal thing, if you're running a business, you want to be able to fire the contractor that day if they don't show up. You don't want to have a reasonable time that could be 3 days later when they're because they're busy doing other work. So you definitely need to pay attention to those provisions. The next section, which really isn't nearly as important, is the recitals or background, where you basically talk real briefly about the history of the company and the deal involved in the contract. Most of the time, this doesn't really have any conditions or any provisions that are going to be enforceable. It's just more clarity that the two parties understand what they're getting themselves into. The next provision is declarations. So declarations are definitions that both parties unequivocally agree on, that there's no dispute as far as what each term, what this particular provision means. But like the example in this slide is, purchase price means $200,000. There's no dispute at all between the two parties that there was an agreement of a purchase price for $200,000. Otherwise, there would be no contract. Now, whether somebody delivered the $200,000 or not is a completely different question, but this should not ever be some point, the clarity on the definition should not be a point of contention. You should both agree, if you're buying a car, you should have the model number, the VIN number, for instance, in the contract. So there's no doubt you're talking about a specific car that you're looking to transfer title to. Representations, on the other hand, delve into it a little bit more. And a representation is a statement of fact that, one party would know that the other party doesn't necessarily, they agree that it's true provisionally because they're relying on the other party asserting that it's true. So if you're selling a property and you, we'll go through the example here because it says the consent. If you're selling a property and you have a bunch of approvals that you need to get, we'll call them consents, and you're saying that you're delivering the title, and all of these approvals for the permits and everything have been reached, the other party is relying on that to be true. So if you don't do that, then you're now in breach of that provision because the other party isn't in a position to do them for themselves. And they're not necessarily agreeing that those things were done. They're agreeing that they are relying on those things to be true. So these are like the situations that one party is asserting, that things are going to be true when the contract is executed. Warranties, which most of us are familiar with, are basically statements stating that certain conditions are going to happen most of the time after the contract has commenced, that they're going to provide that, something will be free of defects and will function in an acceptable pattern for a certain period of time. And that is usually spelled out in the contract. So, and it will also, specify the remedy, the damages associated with with a failure to make good on that warranty. A lot of times it's just what they call rescission of the contract, that they would say, well, okay, we'll have to return your money and take the product back that we sold you, because we weren't able to, wasn't able to be keep free from defects. And this is common. It's common a lot for equipment manufacturing, for the businesses that when you order a specialized piece of equipment, it'll often include a warranty period where it'll specify remedies for providing maintenance and that sort of thing, to make sure that it is up and running. Because in the end, if you enter this contract, you typically don't want to to have rescission. You want to make the product keep making money for you. So usually, depending on the product, there'll be multiple steps before you might get to that rescission state. So sometimes you'll hear the terms covenants and rights in contracts, and these sort of go hand in hand. This slide is rights, this slide is covenants. And you can think of covenants and rights as two sides of a coin. Covenants are the promises that are going to be executed, usually in exchange for money, that you promise either not to do something or to do something as a condition of the contract. If you're buying a vehicle or leasing a property, you're promising that you will make the property available for the tenant and the tenant can take ownership. The rights are the other side of that, in that, a right to take ownership of a property or a vehicle or get service for equipment or however you cut it. So the rights are the benefits that are going to one of the parties in exchange for, often monetary or for another promise. Sometimes you might have two covenants. One party A might covenant one thing, and that party B has a right to, but in exchange for party B covenanting another thing to party A, that then party A has a right to. So it just depends on how that contract is written. Conditions to an obligation. Conditions in a contract are basically statements of fact that have to be met before an obligation to perform is triggered. So the situation that you might be familiar with would be if somebody is purchasing a house, and I think this is less common today, but it used to be more common, that you might make a conditional offer on a house that you have, like, you make the offer for a certain amount of money, you're going to take ownership of the property on whatever date, but it's contingent upon you being able to sell your current house for a certain amount of money within that same time window, or maybe some shorter time window that you have to reach, the closing stage or whatever. So until you sell your house, then you're not really obligated to buy the other house. Now, typically in those scenarios, you want to own the second house, so you're going to make an effort to sell your first house. But that's the situation for a condition, that the obligation to act doesn't happen until certain parameters are met. And the example in these slides are, if you have an insurer, the insurer has to be notified of a claim within a certain amount of time. Otherwise, they don't have to. They're not obligated to pay out. I mean, they're basically putting in their own limitation, a time limitation on when they have to get notice of a harm that was done to the insured person. So that's another example of condition. And if they aren't given that notice, then they're not obligated to pay out the claim. Discretionary authority. These are the weasel words in a contract that say things like, the bank may waive in the event of default. So they're not actually requiring a party to do something, they're giving a party the right to do something if certain conditions are met, but they're not requiring them to do this. And this is common. This is extremely common in a good way for late fees. I know a number of law firms, for instance, will have provisions in their attorney-client relationships that if you don't pay your outstanding invoice within a certain amount of time, that you may incur late fees. But it is very common that if you're, you get a reasonable time, if you're 2 weeks late or something like that, usually they'll be happy to waive the late fees, because the contract will say they may apply late fees, giving them the right to do it, but they don't have to. It's more draconian in scenarios where you're dealing with larger entities, banks and that sort of things, because whether they enforce these rights or not sort of depends on, number one, where their financial position is and how much leverage they have. But these are, this is always important to understand when you see these words in contracts, like they may do something that doesn't require them to do anything, that only, gives them the option to do it. So, and sometimes I see situations where the covenants themselves, which you think you're negotiating for, will have the word may in it. And suddenly you realize, they didn't actually obligate them to perform the action that you were hoping for. So be very careful when you read through contracts and you see this word. Always understand what that means. That means they don't have to do something. And it's, sometimes it's to your benefit, and a lot of times it's not. And so you need to understand that. So that's the overview of the different types of provisions. Now let's get into the typical implementation of these provisions. So another one that's super important to small businesses, and really to anybody, is termination and renewal contracts, because often they're the same thing, or provisions. So when you enter into an agreement for the performance of something that is over time, so it's not like a service or your cell phones, leasing, property, or anything that is performed over a substantial amount of time, the contract almost invariably will have a provision that specifies what happens at the end of the term of the contract. So if you have a lease for 4 years, what happens at the end of the 4 years? Most common for those type of contracts is that they will have a rollover provision to specify that the contract will either reset to a certain number of years again, or it will go to a month-to-month contract. That's more common for particularly residential renting. So you'll go from a 1-year lease to a month-to-month lease. But in doing so, it often also has provisions that the cost goes up, the per month charges go up. And these provisions, understandably, are always written from the perspective of the party in power, and it's usually to that party's benefit. So it's very important to understand what happens at the end of a contract, and just as importantly, how it can be terminated. A lot of contracts include a provision that says you can cancel the contract at any time if you give them 30 days written notice. Now, usually, basically, what they're meaning is they get a free month out of you. You've got to pay them the month, give them the notice, but then you can get out of the contract. It's when you enter into a service contract, I would very much caution all of you to understand what is the lowest cost to terminate this contract, because I've learned through experience so many things can go wrong when you enter into long-term service contracts. And just sharing as a real good example, in the IT space, for anyone that's business is large enough that you're outsourcing IT services, you might really like working with company ABC, when you're entering into this agreement. I cannot tell you how many times I have seen those companies get bought by a larger AT company, and then the quality of the service drops considerably because they're instead of getting getting people that are really good, they're looking at what's the absolute lowest cost that we can have people answering the phones and meeting our obligations of this contract. And if you have that happen and you have an ironclad contract that there's no way for you to just cancel the contract, you can really be stuck with substandard service. So I would absolutely, anytime that you're entering a service contract, understand how you can cancel it, no matter how much you like the people that you're working with, because you can just flat out, be very honest with them. Yeah, I like working with you. If you sell your company to another person or another entity, I may not like working with them, and I want to know what I can do to get out of that contract. So that's just fair warning. Always have an understanding of what it would take to undo everything. So there's also always, to have a decent contract, there'd be a provisions for default. What happens if you don't pay? What happens if a certain set of conditions are happening, and those go hand in hand with remedies. If there is a default, the contract should specify how the one party can recover, and make it clear. This is different than a breach. A breach is when somebody does something that isn't, wasn't in the conditions of the contract, but it's like somebody, if a contract says, you'll have to pay us a certain amount of money, and if you don't, we will come and we will, come get the item back. Basically your non-payment. And so they come and get it back, and then they send you an invoice, let's say for their time and whatever, and then you pay that. That would typically be the end of the contract. Like the contract is now completed and terminated. That wouldn't necessarily be a breach. Whereas in that same scenario, if you didn't pay the invoice at the end, because I'm sure the remedy would say they got the item back plus some extra fees, then they might be able to still claim that you breached the contract. So it's just you can think of the breach and the remedy as, how the two parties can resolve disputes without involving the courts. Another important provision is choice of law and venue. And for anyone that is entering into a lease in particular for land inside of, let's say, Cuyahoga County, you need to make sure that the choice of venue is in fact the same area that the land is located in. You hear, particularly going back to the software end user license agreements, you'll hear that they have arbitration clauses where you have an arbitrator in Florida somewhere if you have a dispute. And again, you don't have any bargaining power in a lot of those scenarios, so there's not a whole lot you can do other than not use the software. But when you're leasing property and you're actually having decent bargaining power, make sure you know where your court would be held. Sometimes sometimes you could get a more favorable jurisdiction somewhere else, but know why they're moving the jurisdiction if it's not local, and be comfortable with that decision, because especially for business contracts, these provisions are going to be enforceable. So knowing that you have an attorney, for instance, that practices in that area, you're going to be in a lot better footing than if the provision included some remote place in Wyoming and you didn't even know anyone there. It would be really hard for you to enforce your legal rights. Indemnification clauses or provisions in contracts. Now, this is an area that I know fairly well because of my background in intellectual property. So indemnification says one party is going to compensate the other party, like basically take their liability from them. So they're going to assume the risk of doing whatever action. So in my world, the most common situation that I see indemnification clauses is for patent infringement. So suppose that you have three companies. You have company A, B, and C. Company C invents a product, and they have a patent on it. Now company A tries to sell a product to company B, and company B is concerned that that product infringes on that patent. And there are going to be a bunch of legitimate and sometimes non-legitimate reasons why that would be the case. So company A can't sell this product to company B in general unless they indemnify company B from lawsuit for patent infringement from company C. So in that case, basically company A is saying, well, we don't think you're going to get sued, and if you do get sued, we will litigate that action. So we're going to indemnify you for the use of our product so that you will buy our product from us. And the legitimate situations that this absolutely can happen is a lot of times you might have company A is in a license with company C to make and use that invented product. And then when they sell the products to company B, what the last thing in the world you want is for company C then to say, well, yeah, we have a contract with company A to for them to use the product, but not for you. So they come after their customers. I'm not saying that happens very often, but that's trying to keep everything above board and understanding, what each party is involved in certainly helps avoid these types of disputes. So you can just sort of think of indemnification as you have one of the contracting parties saying, for certain actions, we're going to assume the responsibility, the costs associated with performing those actions. And, so that might induce you to enter in this contract where that you might otherwise not be okay with entering. Limitation of liability. So a limitation of liability is basically specifying where the contract, ends as far as if one party breaches, what is the maximum amount of money that or other action that can be extracted here. These are very helpful for contracts because they define, you don't have to worry about, emotional distress claims and things like that you might have to otherwise worry about with traditional tort law. The limitation of liability says, okay, we're only liable for, the cost of the transaction plus a certain, 10% or something like that. And so it can cut off how much the damage can be done to one party from the breach of another party. And basically, if you don't have a contractual limitation, you can have a lot more damages assigned to one party than the contract might otherwise provide. So this is a great way to limit your liability for actions. And so this is just an example here of how a limitation of liability would work. Assignments, subletting, very common, obviously, in landlord-tenant. It is really hard to completely block your tenants from being able to sublet. Usually, the more enforceable provisions in contracts for landlord-tenant are situations where you specify provisions that allow subleasing in certain situations. You have to be given proper notice. You got to make sure all of the payments are up to date and all of this. If you just blanketly say no subleasing in the contract, it's very hard to enforce those. And let me give you an example. Suppose that you have a landlord-tenant situation and the tenant moves and then subleases to a subleasee, and this subleaser is paying on time, not damaging the property, but the landlord's just annoyed. They just are unhappy with the situation, so they evict the subleasor, and then they sue the tenant, saying, you didn't have a sublease and you still owe, you weren't allowed to sublease and you still owe payment for the remainder of the term. Courts are not going to be particularly sympathetic to the landlord in that scenario, because they're going to say, well, you didn't do enough to mitigate your own damages in that situation. They found you a leaser, they were on time, the sublet would have been fine. You just, you're trying to go overboard here. There's so many statutes that apply in landlord-tenant that wouldn't apply to other types of contracts, but you have to be very careful about the provisions when you're entering into leasing commercial property particularly to private individuals about this, for this particular issue. So another provision is intellectual property provision, and this is something I'm extremely familiar with. And this basically specifies who owns the IP rights of the product from the contract. So if you hire a software company to draft you, to create a program for you, who owns the source code? Who's allowed to modify the source code? They'll give you the executable copy of it, but they won't want to give you the underlying code that you could then take to somebody else and have them maintain it for you, because they're going to want to keep that, the longer service for you. You need to specify in the contract and be upfront with who owns the rights to file patents, who owns the copyright, and all of that in the contract. This slide implies that that all contracts have this provision, and very commonly they do not. And one of the questions that I get a lot from people is about work for hire when it comes to IP. So somebody creates work during their scope of employment. So they have to be an employee, and they create work. The company is considered to be the owner of the IP. That does not apply for contract jobs. That is not work for hire. You have to specify that included in your contract. And the best example, a lot of you, if you're old enough, are familiar with, when you would hire a photographer for a wedding or something, and they would maintain the rights to the copies of the pictures. So other people that want a picture of the wedding had to contact the photographer to get copies. I know with digital photography, this has changed a lot, and I don't know much about the market today because I've been married for so long, I haven't had to deal with it. But just talking with other people that they're hearing, what I hear back from them is like, it's not the same way as it used to be with that particular industry. But when you do software development, you need to know, who has the right to file a patent application. Is it the creator of the software? Is it the company that hired for the creation of the software? The software. Have that written down, because that's a major point of cost negotiation. If they don't get the rights for the patent, the company paying for the development shouldn't have to pay as much. That's just how that should work. You need to bargain for that. Otherwise, otherwise the drafter of the contract will certainly make sure it's to their advantage, right? If there's no discussion of that. So the last section here, making sure we have some time for questions at the end, is about insurance. Basically, the insurance, as everyone knows, tries to protect the company from catastrophic loss when something goes wrong. So the layers of insurance, you have your primary insurance, your excess insurance, and then the umbrella insurance. Everybody knows, like, primary insurance, like your automotive insurance, just for personal, but it will always have a limit on it. Businesses will often have excess insurance. It's basically the same policy, but it might be from another carrier that adds additional protection. But that protection doesn't kick in until the primary's liability has been exhausted. Umbrella insurance basically covers stuff that not only the liability that was in the primary, but also covers some things that weren't mentioned at all. But it also only, if you do have insurance for it, it will only cover when the primary insurance is exhausted. One of the things I would tell anybody on this call for your personal needs, I would highly encourage you to look into umbrella insurance. It's not very expensive. It can protect you from all sorts of things that are very unforeseeable sources of liability. and you can do it for a couple $100 a year. The only thing I will caution you there on is make sure that your umbrella policy is the same company that does your primary. Otherwise, the umbrella company will have a bunch of reasons that the umbrella doesn't kick in quite yet. If it's the same company, you're going to have a lot easier time moving things forward there. So just be careful there. But I definitely recommend almost anyone looking at insurance should consider umbrella, whether you're a business or an individual. We'll talk about the different major types of insurance here. The first being commercial general liability, CGL. Basically, this is insurance against, that protects your business from harm that happens to third parties. So the easiest example, if you're running a restaurant, if somebody gets food poisoning from your restaurant, that would be a third party being harmed by an action of your restaurant. And so this would be covered under this type of insurance. The second would be first party commercial insurance. So this protects like the business owner, instead of protecting the public, the third party, it compensates the business owner. Suppose that in this continuing the restaurant example, your business burns down. So you have lost wages, lost revenue, and then you have to rebuild the building. Your first party commercial insurance will typically cover that. So so a lot of times these might be rolled into the same policies, but a lot of times you're separate policies. But always understand who can recover from each type of insurance that you have. Sometimes the business owner can recover, and then a lot of times only the third parties can recover from actions taken by the business. And then, of course, there is employment practice liability insurance. So in situations where somebody is terminated or they have an uncomfortable workplace and they quit or feel like they were pressured to quit, a bunch of, I'm definitely not an expert in employment law, is that they can then go to an employment attorney and try to bring an action of wrongful termination, and in these scenarios, the employment practices liability insurance will then, handle the litigation of this. The vast majority of the time for this type of insurance, what happens is they'll offer a couple of months pay to the person that's bringing the claim because it'll be a lot cheaper than litigating it. And then they accept that and move on. Everybody moves on with their lives. One of the most important things to understand about insurance that you're not going to like is that insurance company gets to operate on your behalf, and you don't get to control how they dispose of a particular claim. And using the example of the employment liability, you might think, I fired that person, I'd do it again if I had the chance. They were a terrible employee, and your employment liability insurance is still one to pay them out because it's simply cheaper to do it. And it's a lot, it's something I hear a lot of people complain about that they didn't agree with the decision the insurance company made, but it's ultimately, their decision to make. And this is also goes hand in hand with liability waivers. A lot of times I see people doing activities that, don't look particularly dangerous, and the business will ask them to sign a liability waiver. And it's not because the business is afraid you're going to sue them. What they're afraid of is you're going to get injured, and then your health insurance company will sue them. It's called subrogation, and they will sue them on your behalf. And by having that liability waiver, so that they can't bring that action. So that's why that comes up a lot. That leaves us right at 12:49, just about 10 minutes left for questions. I did want to emphasize that we will have a recording of this available, and a copy of the slides will be available. So let me stop sharing, and I want to see if I can see some questions here. And
Mike,
remind
this
you,
is Mike. This is Dan at the top of the screen. I put all the questions that came in into the chat.
Okay. Top of the. I don't see that.
All right, let me read them to you if that's all right.
Okay.
Okay,
That's
this is
fine.
from Melanie. I have a website graphic design business. Do I need a separate contract for each service offered, or is one master agreement enough? And this is a multi-part question, are terms and conditions enough online when buying a service, or is a full service contract needed? I don't know if these are related or not, but those are her questions.
Okay, so the issue there will be how much different each service is. One of the things that you can always weigh in contract law is that the more bargaining power that both parties have, the more likely the contract is going to be enforceable. You could certainly have a master agreement if it was specific enough that covered each individual service. That would just be, there's not really one better than the other in that scenario. One sounds like it'd be more paperwork, but at the same time, it might reflect more negotiation to make the contract more accurate. So I guess there's good and bad of both, but you could do a master contract as long as it specifies very clearly all of the services. And I would also advise anyone in that scenario to have separate provisions for how each individual service could be possibly terminated if there is a scenario where they could be terminated separately and continue working for some of the services. You just need to make a more complete contract. It says, are the terms and conditions enough online when buying a service? Is a full service contract needed? Well, the terms and conditions are a contract. I'm not real sure what the question is there. The terms and conditions are just a type of contract, and a full service contract is better. Again, it comes down to bargaining power versus if just clicking on a button that says terms and conditions. It's not ideal because there was no good faith negotiation between the parties. But in the end, they're both different. They're just really different types of contracts. One's more boilerplate, and then one is negotiated. But obviously the boilerplate one's a lot easier to put together, but then it's a little harder to enforce. And it goes also back to, are you trying to enforce it against an individual or business? Because it's going to be a lot more consumer protections against individuals. So, okay.
All right, the next question, Mike, is what is the reason for a clause such as, quote, not fit for any particular purpose, close quote? Aren't the parties entering into a contract to obtain a particular result or purpose?
What is the reason?
For a clause not fit for any particular purpose?
Well, without not to see the particular contract that he's talking about, but I would just tell the person that not fit for any particular purpose is trying to imply they are not providing a warranty. If that's what they're saying, that they're not guaranteeing that it. I'll give the example of rope. Because I've literally seen this on the package. It will say it'll show a person climbing a mountain, and on the back of the package it says, don't use for climbing. Can't be used for climbing. Which I don't know how in the world that would be legal as far as a court would enforce that, but what a lot of times they're saying they're not fit for a particular purpose is they're not going to warranty that this particular product can be used for any. They're not saying it can't be used for anything. Otherwise it would warn you. But they're just saying it's not required by the contract terms that it's going to be able to be used for that. And aren't the parties entering a contract that came? Yeah, that's what they're saying is the second part of the question is that the operation of that particular purpose is not part of the contract. That is simply not in the contract. So they're excluding that part of the contract by adding that clause. So that's I guess the answer for that.
Okay, next question. Does indemnify, hold harmless, and defend mean the same thing?
Not necessarily. So indemnify, as I mentioned, to the most familiar with that, the situation where you have one party protecting the other contracting party. Hold harmless is usually that you have one party protecting itself from the other party. Like, you know, if you sell somebody a car, going to that example, you will hold harmless their liability for if you're in a wreck in that car. They're not responsible for, you know, after they sell you the car, that the contract, that's outside of the contract. And defend, that's often going to the example of insurance, that they're not indemnifying you. What they're saying is that if liability attaches to you, that they will defend you in court. And again, that comes with its own downsides because they get to completely take over how that works. So those three provisions are used often in different contexts, and even though they are connected, they don't mean the same thing.
Okay, here's an insurance question. It's a bit long. Let me read it. We only have time for one or two more questions, so I'm sorry for those of you who don't get your questions answered. However, Michael Steele will give his contact information at the end. And if you need legal advice and wish to obtain his services, you can contact him directly. Would insurance carriers issue policies that specifically exclude activities a business is doing and expect the business to know by reading the policies, or would they not issue the policy in the first place? How would I know if I'm covered by the policy or not?
That is a good example of why if it's a particularly important thing like insurance, you need to get an attorney to understand that. So that the question itself, and you did a great job of asking the question itself is confusing because I know exactly what you're talking about. That the policy will start out by, we're not going to cover anything, and then it says we're going to cover certain things, and so it creates all these different types of confusions. And without actually seeing the particular policy in place, it'll be really hard to predict scenarios where you would and would not be covered, because like there are always, any type of insurance, there are always exceptions to what is covered, even if you think, you know, that it should be covered, or a reasonable person would think that such a thing will be covered. And the insurance companies will make sure that they use every loophole they can to not pay. So that's, you know, when it comes to your business in particular, when you're entering into an insurance agreement, that is definitely a time to have an attorney representing you, make sure that you know the ins and outs of the insurance policy.
Michael, this is the last question, and it goes to your practice area of intellectual property, I think. Here's the question. How do I keep parties like the engineers I have hired as graphic designers from taking my ideas and inventing the product they were only supposed to design for me?
Well, in the scenario of copyright, there's two different types of intellectual property at play here. In copyright, if they're your employer, if they're your employee, you can assert, and it will be true, that is work for hire, and that you are the owner of the copyright. If it is a patent issue, you need to make sure that you file for the patent application, because once at that point, when you file the patent application, they will actually assign the patents to the company. Now, there's other ways around that, because there'll still be a work for hire issue of implied and all of that. You can try to force somebody to sign after they leave the company, but it's much better that they sign away the rights while they're still an employee. And you can even make them sign a document that says that, you know, all of their inventions are yours, whether you choose to file the patent application or not. It's not. There's a lot of law that's implied there. If you don't have that in place, you're not dead in the water. But it's always better to have the expectations for engineering work in place and make it very clear to the employees that is your IP, that they are developing it on your behalf. And you'll be happy if, in the good case, when you get a patent, you'll be happy to name them as inventors of the patent. But they will be listed as inventors in the company's name, and that's how that is sort of resolved.
We are now out of time. Michael, do you want to give contact information if people want to reach out to you beyond the webinar?
Yes, my email address is michael.steele@scorevolunteer.org. And not only that, if you contact your SCORE mentor and tell them that you need, intellectual property advice, they'll usually contact me. I would tell you that if over the years, I've done a couple of contract reviews, and the answer is always the same. You need to have a contract attorney look at this. So it isn't really something that I do, as far as, because it's just not my area. But any type of IP work, I'll try to give you a quick answer, and it's more useful there. So.
I just want to mention in closing that everyone will receive a copy of the PowerPoint presentation and a link to the recording. Please give us a few days to do this. It's done by a third-party contractor for us, and they have to have time to process. I want to thank Michael Steele for giving us his time as a SCORE volunteer to this webinar. And I want to thank the 46 people who attended this webinar and listened in. I hope it was useful for you. And now I'm going to close the webinar and wish you a good day. Thank you, Michael.
All right, thank you. Have a great day, everyone, and look forward to my next webinar, but hopefully it'll be more of my expertise in IT. So, but have a great day, and I'm glad I could help some of the people.
We do run a webinar with Michael